Nous sommes en audience publique, Monsieur le Président.
Thank you very much. Mr. Steinberg, who's the next witness and where are we with your lineup?
Your Honours, as advised yesterday, we have a witness who is present and available, that is witness P25. Unfortunately, after the witness preparation session, the prosecution has decided to withdraw this witness from the line of prosecution witnesses for two reasons, essentially. The first is, as I outlined previously during the inter partes status conference, I think it was on the 10th of last month, the relevance of this witness's evidence was peripheral, and I would have preferred to have deferred the decision to call him until after the outcome of the summons process for various other witnesses, since much of his evidence would be subsumed in any event in their testimony, expected testimony, and since substantial portions of his evidence was in fact hearsay from those witnesses. But during the course of the preparation session, for which one of the purposes is indeed to clarify and assess the evidence of the witnesses in terms of the witness preparation protocol, I'm advised by counsel who participated in that session that attempts to clarify the witnesses' evidence unfortunately resulted not in greater clarity but in greater confusion. And their assessment of this witness, which I share, is that his evidence would not be sufficiently reliable to present to this court as a prosecution witness. So for those reasons, I do not propose to call this witness. That leaves us in an unfortunate and difficult position, one for which I apologize again to the parties, and that is that with the withdrawal of the witness 604, who we had hoped to call next, the next available witness would be witness P405. Your Honours, I believe I have outlined in the ex parte session the difficulties that this witness has to travel to The Hague before the end of this month. As presently advised, it seems that the earliest he would be available to testify would be the first week of June. And I regret to advise that in these circumstances, until the 1st of June, the witness does not have any available witnesses to present. The witness 256 would have been one which I would hope to...
You mean the prosecution does not have any other witness to present? You said the witness.
Yes, it does not have any other witness to present. I beg your pardon, Your Honours. Let's get onto so I can see what I'm saying. So my suggestion or my request would be that the session adjourn until the first week of June for the presentation of witness 405. I'm available, obviously, to answer any further questions the Chamber or my learned friends might have.
We understand. Please.
I'm grateful, Mr. President. It was at about 9:30 p.m. yesterday that the defence received intimation from a learned friend that the prosecution now, after 4 years since the witness was interviewed, was seeking leave to withdraw the witness. Your Honour, I would ask to read the short email from my friend because matters should be put accurately and fully in my respectful submission. Your Honour, my learned friend at 9:17 p.m. Wrote, "Dear Chamber, dear Counsel, I regret to inform the Chamber, parties and participants that following the witness preparation session with witness P25 held on the 14th of May, the prosecution has decided to withdraw him as a prosecution witness. I had previously informed the Chamber that the evidence which this witness was expected to tender was largely hearsay from or subsumed by the evidence of other witnesses who are presently the subject of the Chamber's recent summons decision, and that the prosecution preferred to defer the decision to call him until the summons issue had been resolved, and a reference is given. During the course of the witness preparation session, it became clear to counsel that the witness is unable to accurately recall or give a coherent and consistent account of critical parts of the evidence the prosecution had intended to lead from the witness. In the circumstances, the prosecution does not consider that the witness's evidence is sufficiently relevant or reliable to call as a prosecution witness, particularly bearing in mind the limited court time available to the prosecution and the consequent need to present the most cogent and reliable evidence. The prosecution, of course, has no objection if the defense wishes to consult with the witness with a view to calling him during the defense case, subject to the provisions of the protocol. I apologize to the Chamber and parties for the inconvenience occasioned by the late withdrawal of this witness. Sincerely, Anton Steinberg, Senior Trial Lawyer. Your Honour, I have some observations on this. Firstly, in my respectful submission, it is a complete red herring to refer to the hearsay nature of this witness as if it has suddenly become apparent. This is a witness who was interviewed over days by the prosecution in 2010, and he was referred to 25 times in the confirmation decision and 17 times in the prosecution's pre-trial brief. The prosecution knew the nature of the evidence, and they still intended to call him. And indeed, he is the only witness that we have thus far had the hope to have the opportunity of testing, of confronting and challenging, that has come before this court that was relied upon by the prosecution at confirmation. Your Honour, the second aspect is the issue of time. The issue of time hasn't suddenly dawned upon the prosecution at 9:30 p.m. yesterday. It was an issue that was known when this witness was scheduled to attend. So again, that's a red herring. The reason, and the only persuasive reason, why the prosecution would seek to withdraw this witness is because he's unable to give a coherent and consistent account of critical parts of his evidence. Your Honour, this is a witness that we had said at the beginning was conducting a fraud on this court, part of a witness protection racket, paying witnesses from US aid, from foreign embassies that were already being paid, were already in receipt of money from the Kenya National Commission of Human Rights at the request of the prosecution. So, Your Honour, a very important witness for the defence. It's all about the money. And, Your Honour, out of the prosecution witnesses, 5 witnesses relied upon at confirmation came through this witness's hands. And 2 witnesses, subject to the summons, we say have been paid and looked after by this witness. So important for the defence. But the submission of the prosecution in the email needs to be peeled away, we say, to look at the real issue. Your Honour, in our respectful submission, it is premature to give the prosecution leave to withdraw this witness. Your Honour, we have a right, of course, to disclosure. We all know the provisions of Article 67, Rule 77. We haven't even received a proofing note of what transpired in the meeting. We haven't even received that. We don't know the expenses and the benefits given to this witness. And we, of course, have reason to believe that the witness was relocated in 2010 outside of Africa. Again, that's a disclosure breach that we would be interested to know about. And it may have a direct effect on whether or not the prosecution application to withdraw this witness should be granted. Your Honour, the idea that the defence somehow will pick up and run with a witness that the prosecution find irrelevant and incredible and not coherent, it is really, doesn't need much commentary. The defense give an undertaking that if we are compelled to go to the stage of putting on a defense, we will only bring witnesses that speak the truth and give coherent accounts. So that really doesn't give much comfort. Your Honor, your decision, the bench's decision of the 2nd of January 2013 on witness preparation.
Mr. Khan, is that an application to disclose?
Yes, the video. The video,
session,
the video recording.
The preparation session?
Indeed, on 3 bases. Firstly, on the basis of your decision itself, that the party making the request shall satisfy the chamber there's a concrete and credible basis for the request. And Your Honour, this, of course, and Your Honours were very careful, was without prejudice to our rights to disclosure under Rule 77 and Article 67. The very fact that my learned friend has contemplated that this witness could be spoken to by the defence and we'd have, we could call him in the defence case if necessary, provides at least some basis to conclude that the evidence this witness has said in that proofing session is either material to the preparation of the defence or otherwise sheds light on the prosecution case. And Your Honour, we would say that no decision should be made. The witness should not be given leave to withdraw until we've been given that disclosure. Your Honour, if that proofing session took less than 3 hours, I would ask that the case be stepped down until 2 p.m. tomorrow. I will endeavour to review it today and make more detailed and informed submissions tomorrow. If it's a longer proofing, because we've had some proofings that take, many, many hours indeed, Your Honour, it may be that I would require the case to be stepped down until Monday. But Your Honour, to make informed submissions as to whether or not the application should be acceded to, we need to have disclosure. The most basic disclosure that the prosecution are required to give, the proofing note, has not been complied with. Your Honour, given the nature of this witness's evidence and the impact it has both on the summons decision and our submission that there's a rotten underbelly of this case, we would ask to have disclosure. Your Honour, there's been a lot of discussion in this case about cooked evidence, and we make no bones about it. This witness was the master chef. We want to get behind it before we make a decision that he should be allowed to go. Your Honour, the reason I also say it is the provisions of Article 56 may or may not be relevant. The witness is here in The Hague. The witness is available. There's no indication the witness is unwilling. It's simply because the prosecution view now, after 4 years, is not helpful. So, Your Honour, before a decision is taken, I would ask for disclosure, and that is my application.
Is there a logical progression in your position towards saying that the prosecution may have to be forced to call the witness?
Your Honour, I'm not saying that at the moment. We have a right, we say, to make informed submissions based upon our statutory rights. Those rights, of course, we have an expectation will be completed by the prosecution. In addition to those rights, even Your Honour's order that proofing notes be prepared have not been complied with. That's a clear breach. We have an email, but that's not a substitute to a note of what took place. Your Honour, the decision of video link was not to tie up prosecution resources. It was to provide a safeguard. And here, where there is a core witness, relied upon a confirmation, relied upon 25 times in the confirmation decision and 17 times by the prosecution in the pre-trial brief, on the eve of trial, after thousands of hours by the defence, great expense in uncovering the rotten underbelly of this case, to pull this witness may be appropriate, it may be inappropriate, it may be that the defence could deal with issues in a variety of ways. But, Your Honour, before I make informed and proper submissions as to the appropriate course of conduct, we say we are entitled to disclosure. We haven't been given it, and that's the nature of the and the reason for the evidence. Your Honour,
so
this witness was...
1 second. What items, so that we are precise, what items of disclosure are you requesting? You mentioned the video.
I'm sorry, Your Honour.
Of the preparation session, was that it?
Your Honour, the video of the witness preparation session Secondly, the expenses and benefits that have, one, been asked for by this witness, number two, have been provided to this witness and his family since the prosecution first came into contact with that witness, are matters that we say should be disclosed. Your Honor, it's important in this case.
No, before you argue the point, let's first get the item. So first we've got the video of the witness preparation session. You're requesting that to be disclosed, and you're also requesting the second item, which would be the schedule of expenses and benefits provided to this witness.
Indeed, and Your Honor, normally, of course, that's what the prosecution obligated to do in relation to witnesses, and we haven't received it in this case.
Is there any other item, or just those two?
Your Honor, those are the only two matters that come to hand. Of course, that disclosure may necessitate further applications for disclosure. Your Honor, for the sake of accuracy, I think we have only received disclosure until October, relating to expenses, up until October of last year. So nothing since then. Your Honor, there's been, indeed.
So your request then would be expenses and benefits incurred or given to this witness since October 2013.
Indeed, Your Honor. And the third matter is what, if any, agreements, conversations have taken place between the VW and the OTP regarding benefits to this witness. And the reason I say this is that in relation to witness 268 that we've dealt with, after cross-examination was completed, so after we had the possibility of questioning him, we were given a document by the prosecution showing that after he was released, he presented a business plan to the prosecution regarding what he expected to receive. And Your Honor, I need to know if that's the normal state of affairs. The witnesses are kept in limbo with promises of business plans being concluded after they've been released. And that, of course, can have a direct bearing on the reliability of evidence and the motivations of witnesses in the first place. That relates to 268. I want to make sure whether or not discussions like that have been entered into by the prosecution with this witness. Your Honor, it's important to bear in mind.
Mr. Khan, I would like you to rephrase that item as an item on a list.
Your Honor, then it's an additional item which would be disclosure of discussions, whether by telephone, email, in writing, or in person, between the VW and the OTP regarding benefits requested or promised between those entities and witness P25. Your Honor, in assessing, including any deferral of discussion of benefits until after testimony, because that's the situation that clearly happened in relation to witness 268. Your Honor, the importance of this is on the 5th of May 2014, Emeric Rogier, the OTP investigator, said that this witness is a serious and dedicated person, and he was approached by the OTP because his evidence was thought to be important. So it appears to be a 360 turn between the hearsay nature of the evidence and the fact that even in May of this year, 5th of May, his evidence was thought to be important, which of course is in line with the fact that he was a confirmation witness and a pretrial brief witness. So this is an important event. There are occasions in the course of a trial when something happens which gives you an insight into the motivations and the weaknesses or strengths in the respective parties' case. And, Your Honour, we have said repeatedly from the beginning that both there's a rotten underbelly, witnesses are duping the OTP because they are trying to get benefits out of them and succeeding. And we've said that many witnesses have come through the hands of individuals in receipt of money. And we've listed P15, P28, P19, P16, P24, have all come through. And 336 have all come through the hands or been paid for, received benefits from P25. And that's critical in understanding what this case is about. We've said previously, every day this case continues is for Mr. Ruto a miscarriage of justice because of the prosecution failure to do the job. P613 also was paid by P25. And, Your Honour, we want to make an informed decision about what the right defence approach is, and that requires disclosure.
Ms. Sang, defence, any observations?
Good afternoon. We take a rather different position on the withdrawal of the witness. We submit that it's the prosecutor's obligation to present to the court only credible and relevant evidence. And we've just heard the email was read out by Mr. Khan. And on the basis of the reasons indicated in this email, namely that this witness is not sufficiently relevant or reliable, cannot recall accurately or give a coherent and consistent account of critical parts of the evidence, we submit it is the right decision to withdraw this witness. We have in the absence of any concrete information, we have to assume good faith on the prosecution in this regard. And we do regret, however, that it comes so late. It is really the 11th hour. We have used our time and resources to investigate this witness, so we do regret that, particularly in light of the fact that it's taken almost 4 years for the prosecutor to take another statement on the evidence that was anticipated. They've been in contact with this witness, but they've never asked any further questions about the substantive evidence he was to provide to you. And that, we think, could have been avoided. It didn't have to come to this stage. Having said that, we would like to make it clear, we think it is for the parties to decide who to call, who not to call. And even at this stage, on the basis of their reasoning, we support their request for withdrawal. Of course, I would like to emphasize that this withdrawal is final. They say themselves in the email that the prosecution has decided to withdraw. So we would not like to have another situation in the future after the subpoena witnesses, if ever, in the event they testify, that suddenly the prosecutor wishes to call this witness. We say that would be too late. If they withdraw him now, that's it. In terms of the disclosure, we do not oppose that request. We leave it in your hands. Of course, if you decide to order the prosecutor to disclose this material, it's only normal that both teams would receive that disclosure. We want to avoid a situation where one team, because they have made the explicit request, has information that we do not have. So first of all, our request is if the prosecutor at this stage decides to withdraw the witness, then we encourage them to do so. But in terms of disclosure, and particularly the proving note, expenses, and any discussions about benefits, that is also useful. That's not just in relation to this witness, but that is in relation to the prosecutor's policy in general. So to that extent, we do support that request.
Does the witness, from your information you have, from reading the disclosed statement of this witness, does that statement implicate your client?
He does.
Mr. President, can I clarify? So there's no confusion. If it's of assistance, it'll be very short.
Mr. Mr. Ken, I seem to understand your request to also include that it would be meaningful to take up the invitation for you to consult a witness if you had other material to enable you make that consultation a meaningful one. Is that it?
Your Honour, I can only make a decision as to whether or not I wish to meet a putative witness when I'm in receipt of information that I'm entitled to. So what I would like is firstly to receive the disclosure. That will inform whether or not I wish to take up the opportunity to meet the witness directly. Your Honour, I'm not saying at this point, I'm not saying that the prosecution should be compelled to call a witness that they say is incredible. I'm saying that the witness should not be released until we can make an informed submissions on what actually has taken place.
That was my understanding of
grateful.
your application at any event. Okay, we'll leave it at that. Mr. Steinberg?
Thank you, Your Honours.
But perhaps before I do, let me get a reaction of Mr. Nderitu now that he's here, so that you can take in everything when you respond or react. You will be responding to the application, of course, but
Thank you, Mr. President, Your Honours. The position we take is that a party has the right to decide who to call as a witness. And without more, therefore, we would be saying that it is perfectly in order, as we understand it, for the prosecution to withdraw the witness. That is not to say that there are no legitimate issues that have been raised by my learned colleague, Mr. Khan, with regard to disclosure. I think those two are pertinent to the issue at hand. Thank you.
please, Mr. Stowe, proceed.
Thank you, Your Honours. Perhaps I can start by responding to a question, a query, I imagine it was, from Ms. Baseman as to whether or not this withdrawal is final. I can confirm it is final. Secondly, Your Honours, the prosecution's position is that the responsibility and the discretion in presenting evidence to support the charges which the prosecution has preferred against the witness is preeminently the responsibility and the discretion of the prosecution. I submit that it would not be in accordance with this duty and responsibility and the framework of the statute to compel the prosecution to call a witness which it does not believe to be sufficiently reliable or indeed credible. The statute does, of course, provide provisions for the chamber to call evidence should it.
But so I can save you from that. I don't think we're there yet. Nobody has yet made the application to compel you to call the witness. The issues now on the Ms. Bausman has fast-forwarded beyond where Mr. Khan is. So she has said she's prepared now to not oppose the withdrawal, if I may put it safely that way. Mr. Khan's own position is not to compel you to call, but before the witness is released, for you to make certain disclosures.
Very well. I apologize, Your Honours. I was taking it in reverse order. Let me then deal pertinently with Mr. Khan's request. One issue of correction. He referred, my learned friend referred to an email by Mr. Rogier, which he said was sent in May 2014. I understand it was in fact in May 2010 that this email was sent. I'm sure my learned friend just misspoke in that regard. Obviously, at that stage, the investigation was in its infancy. We've moved a long way since then.
Yeah, but that was after the events, though, after 2007, 2008,
Indeed.
that somebody in the OTP wrote an email, an investigator, who we must presume know their job, saying that this witness may be a useful witness. So whether or not it's 2010 and 2014 shouldn't make a difference in that assessment.
Your Honours, is also not entirely correct. This was not an investigator. It was a member of our JCCD whose task is not to investigate, but rather to facilitate cooperation with the various countries.
Thank you for the correction. Thank you.
And this was at before a time when a statement was even taken from this witness. But moving on then to the requests for disclosure, some of them may be dealt with fairly quickly. My learned friend stated that the defense is yet to receive disclosure of the expenses for this witness. That is not entirely correct. The witness expenses were disclosed on the 13th of October last year already. It is true that my learned friends for the defense had asked for an update, which we have not yet responded to, but I can now tell the defense and the court that there have been no further disbursements in respect of this witness by the OTP since then. Regarding the request for disclosure of any discussions between the OTP and VW regarding benefits for P25, I can equally, at this stage, say that there have been no such discussions. The OTP is aware of no such requests by this witness. Regarding the proofing and the request for the proofing note and the video session, the reason why the prosecution has not disclosed the proofing note is not because we're trying to withhold it, but the purpose of the proofing note, as we understand it, is to inform the defense of any new facts and new issues and clarifications made by the witness so that they may prepare for the cross-examination of that witness. Given that the prosecution has decided not to call the witness, it would seem that that would not be necessary. But regardless of that, the prosecution will disclose the proofing note. We have no objection and we have nothing to hide in that regard. Regarding the disclosure of the video, we think that I'd like to refer then to the reasons for the reasoning of the Chamber regarding disclosure of videos, and I refer to paragraph 47 of the Chamber's order finding number 524. In the event of coaching, well, let me start at the beginning of the sentence. Without prejudice to the relevant articles and rules applicable to disclosure, in the event of allegations of coaching of a witness or any other improper interference with evidence to be presented by a witness, the non-calling party may request the Chamber to order the disclosure of the video. The party making such request shall satisfy the Chamber that there is a concrete and credible basis for the request. On being so satisfied as to the basis of the request, the Chamber, in its discretion, may consider whether to review the video recording prior to making any disclosure order, etc., etc. The prosecution has no objection to making the video available to the Chamber. However, we do not see that any substantial basis has been made out for the disclosure to the defense of the video. There's been no allegations of coaching, and the concession, given the concession that the prosecution has made, that the witness is not reliable and that it's not going to call the witness, not sufficiently reliable to call, in our estimation, there is no further disclosable material contained in that video. Anything else? I think that I've covered all of the issues my learned friends has raised for disclosure, unless there's anything else I've missed, Your Honours. We have no objection if Your Honours wants to request the witness to remain here pending any further decision. One other issue, as regards my learned friend's suggestion that something in the disclosure note or the recording of the proofing session, preparation session, would assist him in his decision whether or not to consult with his witness. I submit that that's another red herring, Your Honour. There's the fact that the witness is unreliable, we've conceded to that, or in our assessment. I don't see how the contents of that is going to make that decision any further. Of course, my learned friends can ask whatever questions they wish of the witness, should they decide to consult him.
Can you take a look at Article 67(2)? Would it have any bearing?
Your Honour, it would have a bearing to the extent that the contents of this might establish that the witness is not credible. But that is a concession we've made already, or not, might have a bearing on the credibility of the witness. The prosecution does not intend to call the witness. So I fail to see how any further impeachment of the witness would assist the defense. It's not a case that there's anything additional that we believe is contained in this information. Your Honours, I have nothing further.
So can briefly, 1 minute.
Yes, Your Honour. The first thing is, I do clarify that the investigative note called Investigator's Report from Mr. Emeric Rogier was filed on the 5th of May 2014. So that's the disclosure date. It does, of course, it does say that he had informed the joint team in December 2010. Your Honour.
And it is entitled an investigation report?
Indeed, I have it here. Your Honour, the second thing is that the decision on witness preparation was clearly subject to our statutory rights under Article 67 and Rule 77, and those rights cannot be diluted because of the proofing decision. No such intent can be discerned that the trial chamber intended that, indeed the converse. Your Honour, this evidence is clearly relevant. Looking at 67(2), it doesn't say that the evidence must affect the credibility of a particular witness. It says it must affect the credibility or be relevant to prosecution evidence. And the prosecutor has said this witness provided hearsay evidence in relation to other prosecution witnesses. So one wonders why the prosecution are so reluctant to give a video to the defense. Your Honour, we would be entitled, of course, if we called this witness to such disclosure. The material is Rule 77 or Article 67. We say that it should be submitted without delay. We're grateful.
All right. We will leave it there for now. We will rise and we will reconvene at the usual hour at 2:30.
I'm grateful.
At which time we hope to render a decision on the defense request.
All right. We will wait.